Thank you.
Nice meeting you.
I think I have some eye contact on the
Yeah. No problem. Just.
also because this one.
Well, good afternoon, everyone. Good morning, everyone. We are still in the morning session. This is our fourth panel, our second panel of the day, and our sixth panel of China Inside World Arbitration Update. My name is Jose Antonio Rivas. I'm one of the co-founders of World Arbitration Update. I also teach at Georgetown Law, and I am also a partner at Strategy LLP, a boutique law firm in Washington D.C. We have the great pleasure of having a topic that is absolutely contemporaneous and very important for the ultimately survival of the human race, I would say, but with emphasis in China and with emphasis in Asia. This is the growth in renewable energy projects in the Asia-Pacific region and arbitration as means to solve international commercial and arbitration disputes. Without going in depth into the topic, I would simply like to introduce our moderator. Ian Laird is also co-founder of World Arbitration Update. He is also a professor at Georgetown. We co-teach a course on investment treaty arbitration and ICJ judgments, and he is the head of or leader of the practice of international arbitration and dispute resolution at Crowell and Mooring. And among many things, he has also, during his career, embarked in many editorial projects. He is editor of a OUP publication in invested arbitration and many other aspects. I will stop there and we'll give Ian the floor and take it away.
Well, thank you very much, Jose Antonio. It's a real pleasure to be here again on this panel. We've shifted from our last panel on state-owned enterprises to another very important topic that is gripping the world, so to speak. The movement towards net zero and addressing the climate change transition is not only something that has generated a great deal of interest and activity from a public policy point of view, and certainly impacted and will impact people everywhere, all of us. The changing nature of the economy and so forth. But from our perspective, and we are here at World Arbitration Update, we're going to very much focus on the legal and business implications, and as well, of course, the dispute resolution implications as well. So let me take the opportunity before we get going to introduce our panelists. Starting off, we have as our initial presenter, Maria Camila Brickyard Moreno, who is an attorney at X Strategy and one of the organizers of World Arbitration Update, and it's a real privilege to be sitting here with Maria Camila. She's a law graduate from the Pontificia Universidad Javeriana in Columbia, and she has her LLM from New York University Law School. And she has experienced and done a great deal of work in commercial law, litigation, on international and domestic arbitration. And it's a pleasure to be here with you, Maria Camila. Next to her is my colleague, Hugo Romero Martinez. And Hugo has had a very busy practice in international trade and investment law, as well as arbitration. He is at RRH Consultores in Mexico. Previously, he worked in the Office of General Counsel for International Trade and at the Ministry of Economy in the Mexican government for 10 years. And previous to that, for 5 years, he was counselor at the Permanent Mission of Mexico at the WTO. And between 2017 and 19, he was Deputy General Counsel for International Trade. He's also been a public official involved in the defense of Mexico in international trade and investment disputes. He was part of the negotiating team for the USMCA, that's the US-Mexico-Canada agreement, which replaced NAFTA as the lead of their trade remedies group as well. Hugo has been involved in so many areas related to international trade and investment that it's a real pleasure having you on the panel and providing your insights. We have next to Hugo, Huawei Sun, or I guess I should use the proper Chinese Sun Huawei.
Thank you.
She is a senior counsel in the Zonglun law firm. She specializes in international commercial and investment treaty arbitration. In over 20 years of practices, she's represented clients in international commercial and investment treaty cases under all the various rules you know. She is specialized under the LME arbitration rules and ad hoc arbitration conducted under the UNCITRAL arbitration rules. She has experience and a record of resolving cross-border disputes concerning all different sectors, including energy, construction projects, financial products, private equity funds, real estate, joint ventures, and M&A. So it's a real pleasure having you here, Huawei, and looking forward to your comments. Next to her, we have Jonathan Ellis, who is down the table, is a partner at HKA Consulting in Singapore. He is the non-lawyer on the panel. He's a forensic consultant with nearly 2 decades of experience. He's been appointed as an expert in more times than I can count. Jonathan has acted as an expert in the UK and Singapore courts, as well as through all the usual arbitration institutions, SIAC, LCIA, ICC, HKIAC, etc. And he's provided oral testimony on numerous occasions as the tribunal and has been appointed as a tribunal appointed expert. So we're very much looking forward to hearing further from Jonathan. And then next to Jonathan, at the end of the table, but not the last but not least, so to speak, we have Melody Chen. She is a partner at what is, I guess, as of May 1st, the newly merged A&O Sherman law firm, which we're looking forward to those new developments. That's a big deal. 2 powerhouse firms in the arbitration world coming together. She's in their Hong Kong office, and her practice focuses on complex, high-value, multi-jurisdictional commercial litigation, debt enforcement and insolvency work, international arbitration, and ancillary matters across investigations, antitrust, and data privacy. She has particular experience advising Chinese financial institutions, as well as clients in the energy, construction, and the TMT sectors. So it's great having your experience on our panel today. So it's a real pleasure to have all of you to talk about our topic, which is, as I said, not an easy topic in the sense that growth in renewable projects in the region is something that, you know, we've all seen over the last few years. It's not just a phenomenon in, say, North America or Europe, but it's something that we've seen a great deal in Asia Pacific. And I think from that vantage point, I guess we'll ask Maria Camila to start and give us a little bit of context before we get into our discussion. So I'll pass the microphone to Maria Camila.
Thank you, Ian, for the introduction, and thank you everyone for joining us today. It's truly a pleasure to be part of this panel in the 4th edition of World Arbitration Update. As for the focus of our panel, as Ian said, growth in renewable energy projects in the Asia Pacific region. Why focus on the Asia Pacific? Well, apart from the fact that this panel is currently being held here in China, there are several reasons. The Asia Pacific region is home to half of the world's population, and its demographic reality explains its remarkably high energy demand, projected to rise over time, and its pivotal role in the endeavor to achieve net zero emissions. Notably, China has pledged to achieve carbon neutrality by 2060. However, similar to other big economies in the world, its reliance on fossil fuels has been questioned, with China still being the largest consumer of primary energy in the world, followed by the United States, according to statistics. This implies that the region is in a critical period to join the global renewable movement. And there are already positive steps being taken in Asia in this direction. According to a 2023 market report conducted by Clade Expert Market Research last year, China leads in solar power generation and wind energy capacity, as well as in most production technologies such as solar, wind, and hydropower. Japan, India, and Australia, among other countries in the region, also play major roles in the industry. However, while investment in renewable energy seems promising, it comes with its own share of issues and challenges. Controversies stemming from renewable energy projects have emerged both in international commercial and investment arbitration. Contractual energy disputes may manifest at any stage of the project, from financing to development, construction, or operation. For instance, given the large capital investment involved in these projects, lenders require strong and reliable sponsors. Also, they will scrutinize risk allocation under the long-term power purchase agreements involved in energy projects. And disputes may further arise from performance issues with emerging technologies, changes in grid regulations, supply chains, and price volatility. These are only a few of the challenges faced by stakeholders. In investment arbitration, energy disputes also arise from different sources. According to statistics of the Energy Charter Secretariat, nearly 60% of all disputes initiated under the Energy Charter Treaty involve renewables. Furthermore, according to a study conducted by the Climate Change Council, disputes under the Energy Charter Treaty involving different sources of energy encompass, for example, challenges to the state's regulatory measures, direct expropriation of investments, and discriminatory conduct, such as permit denials. For instance, Spain exemplifies a renewable energy saga where more than 50 arbitrations have been initiated by investors. As done by other countries like Italy, Romania, the Czech Republic, in 2017, Spain implemented a series of incentives to attract foreign investment in renewable energy. While a foreign investment boom was created by this, Spain experienced a tariff deficit. To address such a deficit from 2020 onwards, Spain reviewed and retracted several incentives initially granted to foreign investors. This is what triggered more than 50 investment arbitration claims against Spain. In the latest award issued in January 2024, the investor in solar, wind, and hydroelectric power plants, E.ON, secured one of the largest energy treaty awards against Spain. While the award has not yet been made public, specialized news reports state that E.ON was seeking around 320 million euros. Similarly, countries like Canada have faced constant challenges to its government energy regulation, which cases like the NAFTA case Lone Pine Resources, where a United States based exploration company initiated legal action against the decision of the government of Quebec to halt oil and gas exploration beneath the St. Lawrence River. In Westmoreland Coal, also a NAFTA case still before the tribunal, a United States-based company filed a nearly 350 million claim regarding the decision of the government of Alberta to phase out coal energy generated electricity. Mexico was recently hit with yet another renewable energy investment dispute by Fotovatio Renewable Ventures. This claim is submitted in a scenario where Mexico is trying to reverse the liberalization of energy market, which it implemented back in 2013. In Asia, moving to this region, in Asia, it is worth noting that Japan saw its first investment dispute in 2021, initiated by the Hong Kong-based renewable energy company Shift Energy. While the Shift Energy proceeding has not been made public yet, specialized news have reported that it stemmed from Japan's progressive reduction of subsidies initially implemented to bolster renewable energy through feed-in tariffs. The award was rendered last year in favor of Japan. Now, since China has also implemented subsidies as an initiative to support the development and growth of the renewable energy industry, and since it has a wide network of investment treaties, the state may want to consider the lessons learned from the experiences of other countries if and when it ponders adjusting its policies. A key question arises concerning any existing policy of China subsidizing or supporting renewable energy incentives. For instance, what companies may be receiving the incentives? State-owned companies, private, domestic companies, and/or foreign companies. And subject to the answer, which our panelists may have a clear view on, the chances of arbitration disputes may increase. Following this introduction, our esteemed panelists will delve into the impact of renewable energy growth on arbitration within the region. They will delve into experiences with investment arbitration and international commercial tribunals involving Asian parties in energy projects, whether these are applicable to renewable energy disputes, and the unique features of damages calculations in such disputes. So without further ado, I yield the floor to our panelists. Thank you.
Thank you very much, Maria Camila. That was a great way to set the table. Let me first then go to Jonathan and continue to kind of set the context of the discussion. If you could give us a sense of what you've seen in terms of investments into renewables across Asia, since we're here and this is an absolutely critical area of growth. It'd be great to hear your sense being in Singapore.
Yeah, thank you very much, and thank you very much for everyone for being here. I think I'm here for a few stats, basically, kind of start off with some numbers. Maria's kind of started there was a good overview, but the sheer scale of renewables across Asia is huge. Specifically in China, it's the market, it's the world leader in installed capacity. It's got about kind of 1.4 terawatts. We've got kind of 1,453 gigawatts of installed capacity of renewables, which is market leading and is nearly 3 times bigger than the next country of installed capacity. In Asia, kind of the 3 big ones are China, India, and Japan, with the installed capacity here. They have already invested in that capacity with a mix of solar, wind, and hydro. The next thing I wanted to touch on kind of was about how that has changed over time. And one of the key points which was mentioned before is about kind of issues of subsidies. So governments have provided subsidies in the past for renewables to get them off the ground. The complication with that is specifically around solar, is the costs of solar have plummeted dramatically. So the average cost per kilowatt was about 5K in 2010, and it's now under $1,000 per kilowatt. So there is a nearly 80% reduction in costs for installing solar power. You can see that as kind of one of the issues when if you had high subsidies at the beginning, they're not necessarily as relevant now because the cost to install and the capital you need to employ is so much less to install the capacity. Wind, on the other hand, there has been a slight reduction in that, but it's not too much. I think it's about a 30 to 40% reduction over the same time frame between 2010 and now, but that hasn't been as consistent a reduction as it has been for solar. So I think that was kind of the two parts of it. The sheer capacity that is there. In 2023, China installed about just nearly 200 gigawatts of capacity, mostly in the solar space. About 150 something were in solar, and about 40 were in wind. So kind of again, there's still investment going on here, and that's much more than there were previously. In the rest of Asia, Vietnam is probably leading the way in Southeast Asia. It has that's where actually I see quite a lot of activity, I should say. And I think it's about 19 gigawatts there of a mix of solar and wind. The final thing I was going to point out is the fact that in the next, leading up to 2050, people expect about 40% of the world's investment in renewables to be deposited in or deployed in Asia. So this is a huge market that will always kind of keep on growing for the foreseeable future. Yeah.
Well, thanks very much, Jonathan. Those are some sobering numbers, and clearly there's going to be a great deal of activity and investment in the region. And as is the topic of this conference and this panel, we want to do an examination of I guess the impact of these developments in the dispute resolution field, and in particular, what role arbitration may play. But let's kind of dive into your experiences in terms of the types of disputes you've been seeing in the renewable sectors, and if you could give our audience a sense of some of the trends you've been seeing in the growth of those disputes. So I guess some of the questions we can ask are, what are some of the typical issues you've been seeing, and particularly it'd be great to hear about your experiences. And maybe I'll kick off with Huawei. If you could discuss some of your experiences with Chinese investors, that would be great.
Thank you, Ian. Thank you for WAU and BAC for inviting me to join this interesting panel. And I would like to echo Maria Camila's summary of typical disputes in the renewable energy sector, which is entirely in accord with our experience. At first, I'd like to address the disputes related to the host states' change of the favorable mechanism to the renewable energy sector. And so as far as the Chinese investors are concerned, they have started early to participate in the outbound investment to avail themselves of the favorable mechanisms such as feed-in tariffs adopted by European states. Just now, Maria Camila mentioned the huge disputes against Spain. In practice, for Chinese investors, we have also seen similar disputes in the same industry. The disputes involved the PV power station and the solar power plants project in Bulgaria, Romania, and Greece. As it has become known, huge financial subsidies have resulted in overcapacity in the industry. So as a result, in order to alleviate the financial burdens, the European states rolled back their incentive programs, which caused a loss to the renewable energy producers. The measures in disputes included imposition of the grid connection fees and other fees on the renewable energy sector, reduction and abolition of the feed-in tariffs. And the situation gives to common questions whether the state measures would constitute expropriation or violation of fair and equitable treatment. For Chinese investors, we haven't seen any to go to the investment arbitration to protect their rights. According to our experience, that was because sometimes the value at stake was not very large. And as for the Chinese private investors, normally they would purchase the political risk insurance from Sinoshore. So when the disputes happened, they would first go to Sinoshore to seek compensation. The risk of expropriation covered by the insurance policies is different from the concept of expropriation and international law, because for the former, this is depends on what the coverage set out in the insurance policies. And if we look at the typical insurance policy, normally the scope of coverage is larger than expropriation and international law. One example is that for the insurance policies, the kind of risk insured may include the partial deprivation of the investment. So even if it's not total deprivation, as long as it fits into the contracted description, this will fall into the scope of the protection. So sometimes investors can get remedies from the political risk insurance. So this is one of the cases we have seen. Another type of the disputes is disputes arising from the price volatility. In the process of performing the long-term contracts for purchasing new materials to be used for renewable energy sector, the significant price changes in the international market may affect either party's intention to continue to perform the contract. As a result, there are claims about the breach of the contract and whether the price should be adjusted to reflect the international change of the situation in the market. Then normally the supplier would like to increase the prices on the back of the increase of price in the raw materials. So for this type of situation, it depends on how the contract is drafted. And we would normally suggest that there are some mechanism to allow for the price escalation or price review mechanism in order to protect against the increase of the raw materials in the inputs. So this is another typical type of disputes. And in addition to that, it is said that mostly renewable energy disputes in China arose from the construction contracts and the supply contracts. The loss claimed in such type of the disputes have its special features, because sometimes the damages claim would include the loss of power generation. So the issue would be whether such kind of the loss can be obtained when there's a breach of contract. I will stop here, Ian.
Well, thank you very much, Huawei. When you mention the use of political risk insurance and the fact that perhaps the value is not large enough to generate a potential ISDS case, do some of the other, I don't know if you were here for the previous panel, but there was some discussion in terms of, state enterprises in particular, of the hesitance of bringing ISDS cases, not, partly sometimes can be for political, well, not political, but more diplomatic reasons, avoiding kind of the confrontation that a big public ISDS case might generate. Do you think some of those factors may play a role as well?
Yes, Ian, I think that is one of the factor, but at the same time, I think Chinese state-owned enterprise is not a unique situation. All the companies who want to bring investment treaty cases would have some concerns over the long-term development of the investment in the region or in the country. And for the Chinese investors, I think there's another hurdle is because for many old generation Chinese BITs, the scope of protection for arbitration is narrow. So we have conducted some review of whether it is possible to bring investment treaty arbitration and the particular BITs. So it's after the for the state-owned enterprises, normally they would want the comprehensive analysis with the risk to be assessed. So I think that also accounts for the factor why there are not many cases brought against foreign states.
Yeah, that's an interesting point. When you look at the number of bilateral investment treaties that China has signed, it's actually one of the leading countries in the world, but a great percentage of those treaties are what we call the old style treaty, which was very much focused on compensation for expropriation rather than fair and equitable treatment. And I think you mentioned the fair and equitable treatment element. For those of you who are familiar with the Spanish feed-in tariff cases, as Maria Camila mentioned, there's been over 50 of those. And the main ground for those cases has been this standard that is typically found in bilateral investment treaties concerning the idea of the responsibility of states to give fair and equitable treatment to the foreign investors. Do you see the fair and equitable treatment issue coming up with your clients as well? Do they look at those tariff adjustments? And as you say, there's been a rollback. Is that something that they're looking to applying, Huawei?
Yes, indeed. I think in all of the analysis, fair and equitable treatment is a big factor to consider. But as you said, the constraint that the investment treaties sometimes do not cover fair equitable treatment in the scope of arbitration. So that is also the negative consideration to bring any action.
Well, thank you very much. Those are some good insights and background. Let me go down the table then and ask Jonathan again to give us some sense of your experience in the types of disputes you've been working on as an expert. It'd be good to hear some examples from you.
Sure, thank you very much. I think I'm just going to split this into three, the three main ones of solar, wind, and then hydro. I'll be quite quick on hydro because they're normally quite big projects. So they're a bit more like a normal construction project. Fair enough, there is specific technology there and there's complications within those, but it's more like a normal construction project. With the issues you face, the price escalation, which Huawei talked about, is exactly one of the issues we face. There's our political issues in the world that have affected markets for raw materials. Those have made some projects very complicated. What they have also seen, or what we're seeing, is the decoupling of indices from actual prices in certain projects, and that makes it more complicated for contractors to basically get the raw materials and be compensated appropriately. As we'll come on to, you can also get compensated inappropriately for those where you're not actually affected by the indices, but the indices move, and therefore you get a massive price, a price increase as the employer, and the employer gets a bit upset about that as well. So moving on to solar. Solar is fairly well established. Lots of the things that we are dealing with that are actually shareholder disputes, performance guarantees, contractual disputes, even M&A, to be perfectly honest. It's a lot of that downstream work. Wind is a lot more interesting from a nuanced point of view, because wind is, especially offshore wind, are incredibly complex for different reasons. So we're doing a number of offshore wind projects, and the thing that is mostly feeding into that complication is weather and the issues you have about deploying or making those offshore wind turbines in the weather conditions that you have, specifically in the Pacific. You have typhoons. The contracts have a risk allocation between the contractor and the employer, and they try to replicate somewhat the true nature of the disruption that you faced from these adverse weather conditions. Again, not necessarily true reflection of reality on the ground there, but the contracts for wind that we're seeing are really quite complex risk allocation contracts, and they're really interesting to be involved with. Just to use an example, is obviously if you have a busy if you're planning to do a significant body of works to catch up, or for acceleration measures, and you have a typhoon during that time, you're not going to be able to accelerate. And if you suddenly then get into a season where there is limited availability for you to deploy your ships and to be able to put your wind turbines, you're then going to be in quite massive delay at the other end. And so these all feed into the work that we do and trying to describe that story to everyone so the contract can be effectively managed.
So Jonathan, just on that last point, you talk about the complexity. Complexity inevitably leads to disputes. I mean, do you see that the parties are being reasonable in terms of their identification and acceptance of these types of situations? I'm sure there's every effort to predict, but as you said, it perhaps less than perfect. Have you been seeing disputes arising from these situations?
The projects which I'm aware of and on are all live projects. So they haven't got to the stage of the full arbitration. They're still ongoing, and we're providing support to the contractors and employers in the course of that project. So the disputes itself, the proper arbitrations haven't kicked off yet on those ones. I know that we have supported arbitrations in the past where they have got to that stage, but these projects are quite long, kind of a long term. They're not, a solar plant, you can put a concrete slab down and stick some solar panels on it and it's ready to go. Wind projects are a lot longer lead time and have a lot of complex areas in them, so they are a bit longer. So I think when projects are live, everyone really wants to get to the same thing, which is having a producing project, and so there is a incentive to not necessarily settle, but kind of to find a way forward, and that is what we're seeing at the moment.
Okay, well, thank you. Those are some good insights. If we could move a little further down the table to Melody Chen. If you could talk a little bit perhaps about some of the concerns we've seen with developers and projects and kind of your experience from that side of things.
Sure. I think Huawei and Jonathan has already covered a lot of the issues that we typically see from these sort of projects from the construction perspective. But I think, interestingly, particularly with all these renewable projects, one of the main, some of the kind of pertinent features in it is the fact that, firstly, we're looking at, and particularly in APAC, we're looking at various jurisdictions where there could be obviously very developed jurisdictions like Australia, Singapore, but there are potentially less developed countries like Laos, Vietnam, and so on and so forth. So, well, I'm not going to put Taiwan in that bracket, but considering that our experience in that, we have seen disputes arising out of those projects, which is in relation to the local partnership, because as you're probably all aware, with a lot of these energy projects, local governments would require a certain level of local participation and sometimes majority participation in the projects. And as a result, very often foreign investors investing into these projects will be working with the local partners to build, run, operate those projects. And that brings in the cultural differences and the misunderstanding, or particularly in relation to corporate governance, the expectations of the different parties. Very often you will have foreign investors with the background of common law corporate governance expecting things to be done in a particular way, whereas with local governments, local parties having, based on their own local experience, would be running projects in a completely different way. And this mismatch of expectation has given rise to some disputes that we've seen. Also, at the same time, I think we've mentioned local government, and Huawei was talking about sometimes, parties do not want to go all the way to an exit disputes. And I've previously been involved in a situation where, obviously we'll need to discuss with the local government, because they will be a very essential party to that local partnership as well, and how to, actually resolve. And, for example, in relation to delay arising out of it, or problems in relation to construction, how we manage all of those different aspects. I think the last point also in relation, probably more in relation to the local partnership, is inexperienced labor. Obviously, we are talking about a lot of new technology, new areas to develop. There's a lot of unknown involved in all the construction and all the operation as well. And coupled with inexperienced labor, that could we've seen that's bringing different disputes or troubles out of it. That's kind of more on the local partnership side. Another side to it that we've been involved in is in relation to the financing side. Obviously, all of these projects are requiring significant investment. So apart from what I've said, foreign investors, private equity investing as an equity investors, you will also have the bank finance or the traditional financing borrowing. And that's often linked with the building and operation of the projects as well. So, what Jonathan and Huawei was talking about, when there's delay, when there is problems with the construction, then, moving on with the timetable, you'll have difficulties in completing, and your completion date will be pushed on, and your commercial operation date will be delayed. And as a result, how are you going to fund the actual financing of or the repayment of all the loans? So from that perspective, I think there's a financing angle to it. And also some of these, obviously we are aware, especially with the less developed countries, they may be getting funding from the development banks, from the international organization, and those are targeted at, for example, a green initiative funding. And there's also potential disputes. We haven't actually seen any yet, but potential disputes as to whether the funding are actually used for the right purpose. The green projects that you're doing, is it as green as you contemplate it to be? Are we meeting the environmental standards that we're trying to set, and so on and so forth? So at least from our perspective, some of these are kind of bubbling at the moment. We haven't actually seen an arbitration or out of that, but I think those are disputes that we are seeing as potential problems.
So thank you very much, Melody. I mean, the local element is obviously key, because these are projects that are essential to supporting policies, on climate change and the government objectives to net zero. So there's some urgency and importance to them, so that there are those local stakeholders, and as well, it's an urgent and important issue to the government. So it's understandable that the various governments would take a direct interest. Do you see that as being something that is, it's understandable, but is that something that is particular to Asia Pacific, that kind of level of engagement? How do you see that, so say compared to North America or Europe or other regions?
It's a bit difficult for me to say how it's compared to the other region, but we've definitely seen quite a lot of interest from the government. I mean, this morning I was watching Bloomberg, and the president-elect of Indonesia is talking about, moving on to a green country and moving on to renewables. So definitely from a national level, I would see that government has a very keen interest in ensuring renewable projects are being pushed forward. But just on that particular point, and also on the urgency side, I think sometimes we also need to take into account the local governments as well. Obviously, within a particular country, you have your national policy, but you also still have your local government. And the importance of that is a lot of this involve, significant projects where you'll probably need to deal with land use rights, and you'll need to deal with local government getting different types of regulatory approval. And sometimes there could be a potential non-alignment in terms of their sense of urgency in that, and that has also potentially causing delays and problems arising out of the constructions and everything as well.
And we've been mentioning kind of in various contexts, the example of some of the European bilateral investment treaty cases, and particularly Spain's, and that related to feed-in tariff type issues. And the standard, and we were talking about that with Huawei, is called fair and equitable treatment, which goes to concepts that's developed over the last, say, 25, 30 years, called legitimate expectations or reasonable expectations. Has that concept, is that something that's being digested by the regulators and governments who are also, in similar situations of trying to incentivize investment, but also being very cautious about not over-promising or creating a regime that could end up being problematic?
I think it's yet to be tested. We haven't actually seen that, and obviously, probably from different parts of the world, there are more incidents where potentially more developing countries would take that sort of standard less importance. I think within APAC, as investment treaty cases become more and more prominent and kind of internationally known, I think that is something that they are becoming to be aware of. But at the same time, they are obviously considering what sort of policies that they will be running and what would be more favorable from that perspective. So I think there is obviously a tension between the two, and I think that's something that we'll need to wait and see how it goes.
So just to kind of get down in the weeds on that, I mean, is this something, and maybe this is a question for all of you, and I'm kind of indulging my personal curiosity, is this an issue you talk about with your clients? Do you kind of look to those other parts of the world which have been dealing with these very sensitive issues and say to them, look, this is a lesson, a cautionary tale, so to speak? Definitely.
I mean, in terms of discussing with clients, we do, as part of our consideration, advise clients to consider what sort of BITs involved in the country that they're investing, and as a result, how you structure your project to take advantage of those relevant, treaties and whatever that's available. So that's definitely something that we do consider when we're advising clients, particularly from a structure perspective, right from the beginning. So if anything were to happen down the road, then they will be properly protected.
And maybe I'll go to Huawei on that as well. You kind of opened up the can of worms on that, but what do you think?
Yes, I think that is part of the consideration as a result of the Chinese outbound investment over the years. I think for many Chinese companies, the structure is not only like Chinese and host state BITs. There may be some intermediary for example, the investment made through some vehicle companies, even in the US or in Canada, because of all these acquisitions. So this is one of the considerations. And on the other side, I think if you look at the change of policy in different countries, Spain is a special country which has a radical change. In some other countries, the change is not that radical, and that would affect analysis of the fair and equitable treatment. And also, looking at investment treaty cases, there are also some pro-investor interpretation or pro-state investigation. So all these factors may come into play when they make analysis for a specific situation.
Yeah, I mean, you raise a good point, and this follows up from our earlier interaction that part of that advice that I think good counsel makes is a structuring one as well, in terms of how investments are structured in any jurisdiction. You know, you look at tax implications, you look at corporate issues, and as well as you know, the protection from international treaties. I think that's always an important consideration. Well, I think that those are a good set of discussions to move on to Hugo Romero, who has had a lot of experience in investor state, but as well as looked at some of these clean energy projects and has some examples as well for us. So Hugo.
Yeah, thank you. I think what after hearing the discussion, what I consider important is that from the beginning, politics play a role in this kind of proceedings, or disputes, but also the parties that are not involved. For parties that are not involved, I will say precisely politicians, but also local communities. Politicians, when are considering or approving these kind of projects, then change. When new politicians came, then they judge that it is not convenient to continue with that project, and at some point change the project. And there is a dispute. Huawei mentioned the radical change in the case of Spain, which is, I think, the reason why 60% of the cases under the renewable energy, under the Energy Charter Treaty, is against Spain. But there are other few examples or cases where local communities play a role, and in these communities at some point feel that they have rights that the project should respect, and then problems also are there. I don't know how it's precisely in this part of the world, but in other countries, I could mention some in Canada or Mexico, where there are federal authorities involved, local or provincial governments and municipal governments. And those, when they are not from the same party in power, or where they simply change the person in charge, then there is a problem. Possibly in a state with a central government could be easier. But that's one part of the. I didn't provide you the examples, but how if we see the car industry in a case against Canada, maybe it's familiar, Ian, for you because you're a Canadian, but a change in the government play a role there. So I could mention my home country, where the new president, or not new, but after 5 years, considered that the policy regarding the energy and oil has to change, and then a change was done not only or not necessarily in the law, but in the application of the law. And currently, the United States initiated a case, sent a request for consultations to Mexico, which has not went to the panel proceedings, but I think that's one part in the ISDS cases. Another part, which I think it wasn't mentioned during these days, and I understand why it wasn't mentioned, there are cases that are, we mentioned here, commercial arbitration, investor-state dispute settlement mechanisms, but also the state-to-state. The state-to-state cases are also involving the renewable energy. I can mention the Canada Feed-in Tariff program initiated by the EU, or the United States on photovoltaic products initiated by China in the WTO, or US renewable energy also, but cases also within the regional trade agreement, which is another way to solve disputes. I was willing to bring this investor-state, state-to-state, in addition to investor-state, just as a possibility to try to remedy or to provide a solution. It is true that commercial arbitration are more common. Also, the use of local tribunals. In the middle, possibly, we're taking a comparison with a pyramid regarding ISDS, and on the very top, the state-to-state mechanism, which is not very common, but it could be used, especially considering that when a country is challenging a measure, even if it's not obtaining the damages, it implies that the measure should bring into compliance, and bringing into compliance means a remedy for everyone. So I think that's another avenue to try to solve disputes.
So, Hugo, when you talk about state to state, would you see a role in the future? Granted, it's not being as active, but for the WTO and these, I know that's your background, you've worked there. If you could give us some views on that.
Well, currently, maybe some of you know that the appellate body is not working since 2019. Even if ministers, the WTO set a deadline to fix this by this year, it will take time. However, regional trade agreements also have these state-to-state mechanisms, and also is a way to resolve disputes. In the case of Mexico, for example, when the North American Free Trade Agreement was not working well in terms of dispute, parties, Canada, Mexico, and the United States, used the WTO. Now that the WTO is not working well, parties are using the United States-Mexico-Canada agreement. So I think that's another avenue. I wouldn't say extraordinary, but they are not very common. But I provide some examples on cases regarding renewable energy.
Okay, well, thank you very much, Hugo, for that view of kind of the North American side of things. Just before we kind of move on from talking about kind of the types of cases and trends, I just wanted to ask Huawei to discuss something that we talked about earlier with regard to ESG. And I know this is a very popular topic. Certainly our corporate clients spend a lot of time thinking about those types of concerns: environment, governance, social issues. So how do you see that issue in terms of potential claims? involving renewables, I guess. I mean, you know, if there's anything environmental, it's a renewable investment.
Yeah, if you look at the other side, the states have also implemented some requirements for investors to comply. So ESG requirements is one of the trend to be included in the investment trade and treaties, trade and investment treaties. So we have seen these arrangements in the treaties, and it's in practice, it remains to be seen that how the states would start to enforce these new type of claims against investors. So I would just like to mention some of the treaties that have such kind of provisions to kick off the discussions. The first, we note that the Australian-Singapore Landmark Green Economic Agreement, which was signed on 18 October 2022. This was a non-binding agreement. It's a framework agreement, but this has already shown the country's effort to achieve the zero emission target. So these are one of the examples of the states have embarked in to increase the environmental obligations for the investors. And another example is the Netherlands 2019 Model BIT. There's an article providing that investors can be held liable for failure to comply with the UN guiding principles on business and human rights and the OECD guidelines for multinational enterprises. All of these treaties have some specific obligation to comply with. The third one is the India Model BIT 2015. There's an article saying that damages are reduced to account for the harm caused by the investors to the environment of local community. So all these mechanisms have been included or may be included in the future BITs. This is the trend I would like to mention in our discussions.
No, that's a really interesting one, and one that's been a topic for a couple of years now, more broadly in terms of the idea of counterclaims, and the idea that a respondent could make a claim against an investor for obligations of the nature that you've set out, that you know, rather than the treaties being maybe a more one-sided protection of the investor through those international standards, that it be more of a two-way situation. And I think ESG and those types of treaties that Huawei set out is again one of those considerations that I think not only applies in the renewable sector, but for investors around the world when they're looking at jurisdictions and treaties, potential treaties that are applicable, that these types of standards may be something to consider. So that's a really good point to raise. It's one that's generated quite a bit of discussion and certainly a lot of interest from our treaty drafters when they're working to create balanced treaties. So we've set the table. We've talked about some of the trends and potential disputes. The topic ultimately for today is, you know, when we're looking at renewables and the development of that sector, this is something that will, and we've seen examples now of existing disputes, past disputes, and potential disputes. Now the question for us, and we're sitting here in the Beijing International Arbitration Center, is that, you know, is arbitration kind of the mechanism that we want to look to for dispute resolution? And you know, as we always discuss, there are options, and you know, as I think one of the airlines say, you know, thanks for your service. We know you have choices, but our clients have choices too when they're drafting agreements and working on these projects. arbitration is certainly our favored dispute resolution process. Courts are, of course, an option. Mediation is always an option. And frankly, just, as we were talking about with Jonathan, if the parties are very conscious of the risks and working together in a good faith manner, that actually solves a lot of problems and heads off a lot of potential disputes. And maybe I'll start off with our expert. I know you've been working on a lot of these issues lately, but tell us from your perspective, how you or maybe your clients are viewing arbitration as an option. Is it attractive? Are they looking at other means for resolving disputes? What do you think, Jonathan?
Yeah, thank you very much. I think there's this might be reiterated a number of times from different people, but I think one of the things that we really like about arbitration from most sectors is the flexibility of it, and the way that you can shape it in a number of different ways. Litigation is very good for certain disputes, but it's sometimes a little inflexible. I appreciate that Singapore, where I live with my family, they have new rules of court which are actually become a lot more like arbitration to try and attract people to litigation rather than arbitration. But it remains the flexibility. I think quite often arbitration is there for the cross-border stuff. I think that's the big thing where you do have parties, and Melody mentioned difference in culture. I see that as when I get involved as a difference in expectations as well, expectations around behaviours and other elements, and that's quite often where things let down in projects. Having arbitration as your resolution mechanism allows you the flexibility to appoint or potentially appoint different people from different jurisdictions, the neutrality. Sometimes it can be seen that if you are in one jurisdiction and you have a decision maker from that jurisdiction, that can be complicated. Giving a little plug to people like myself, arbitration normally allows experts to be on the panel as well. I don't do that, I could point out. I do determinations, which is slightly similar, but kind of the idea of being an arbitrator scares me. So I'm going to stick with being a witness, kind of, which some people might not like as much because you're cross-examined, but there we go. So I think that it's that flexibility that's there. I think one things that I have seen that are really fun and interesting about arbitration is the ability, which we talked about previously, of things like arb med arb. The idea that in arbitration you can normally try and take things off the table, and people are willing to do that. If you can get some resolution, especially in construction projects where you've got 130 issues that are on the table, and you go, right, well, 125 of those are really small and it's about the same. So how about we just choose to park those and we'll go and sort those out. And these 5, which are critical, huge, and really complicated, let's focus on those. And that kind of, you can do that. Whereas in litigation, certainly the ones that I've been involved with, you can't really leave a stone unturned. You've got to go and do it because you don't really know where it's going to go. So I think courts are more flexible. Certainly in Singapore, they do like mediation. There's agreement. The Singapore Convention is all around mediation. But I think in other jurisdictions, it gets complicated quite quickly. So I think arbitration is preferred by most people.
You mentioned a couple of points there. Actually, this is one of the interesting elements of arbitration, and I've seen a number of examples where arbitrators are experts, non-lawyers, have been arbitrators, and in certain types of cases, which have a technical element, particularly economics, as well as certain subject matters, certain industries, it can be beneficial. I agree, it's not the usual kind of environment or milieu that most experts are used to, but frankly, that is, as you say, one of the flexibility benefits of arbitration, that if the circumstances warranted, that is a possibility. Even if you look at the ICSID rules, in terms of arbitrators, it really goes down to the expertise. If you can meet that expertise and you have that background, as many experts, like yourself do, then there's a possibility in the right circumstances to be part of the process. The other thing I wanted to ask you about is your experience as a tribunal appointed expert, if you've had that experience. And tell us a bit about that, because, as a practitioner, I'm always a little leery about the tribunal kind of taking that initiative, because, they're bringing in someone that you don't have direct access to, you can't engage with in quite the same way that, you'd like to as counsel. Just tell us a bit about your experience, Jonathan, on that.
Yeah, so I've been appointed as a tribunal appointed expert in a commercial arbitration, LCIA, and it is rather novel. I've got to be honest. Not many people have. Lots of people have kind of said that's quite odd. I think it's in the UK, where I'm originally from. Fair enough, I've been in Asia for nearly a decade. There's a lot of use of single joint experts in smaller disputes. And there's a move towards that in Singapore, where I practice as well. And so the idea of someone sitting in the middle of being independent, it kind of is fairly normal to me. And so the idea of being a tribunal appointed expert is not that complicated. I think it really depends on the power of the tribunal, how much they're on top of it, and how the parties react to that as to whether it's a success or not. I've been part of two that stick in my mind, which is the first one, which was the one that I was the tribunal appointed expert, where it was effectively a determination. So as a tribunal appointed expert, you went out to the parties, got submissions, you brought them back in, you asked them questions, you went back out and you wrote a factual paper about the fact pattern, sent it out to the parties, they checked it, and then you layered on top of that evaluation. And that was effectively a process where they went through their resolution, then that recommendation then went to the tribunal, and in fact after that point the parties settled. So I didn't get cross-examined, so that was a bit of a shame. I would have quite liked that, because it's quite novel to do. The other one that I was involved with, it was a construction one, but I was there to provide the support to one of the construction professionals, was where there were two parties and there were just ships passing in the night and they refused to engage. And the tribunal was a bit lost. And so they introduced a tribunal appointed expert to effectively knock the experts' heads together to try and get some level of interface between their two positions and try and bridge that gap. And that was quite complicated, quite difficult to do, but we managed to get a joint expert report between the experts, which allowed that position to be understood by the tribunal and then therefore be resolved. And I've also heard horror stories as well of a tribunal appointed experts, but I haven't been involved in those or rather the feedback I've received about my roles in them has not involved that. It can, if not done correctly, just create another layer of complication and delay. So I think you need the tribunal to be on top of it. You need the parties to be on top of it. And in this right circumstance, it is incredibly efficient and powerful, would be my view. And if it's not the right circumstance, we don't need to go there.
Well, I think it goes to the point that, these are tools that are available, and, our topic is renewable arbitration, and there's a lot of technical elements to these types of cases. So I kind of raised it in that context, that, it could be a potentially useful mechanism when you get into some of those more technical, whether they're, construction elements or, concerning, any of the economic issues.
I totally agree. I think that the time where there can easily be a right answer, and if you get the good expert to opine on those things, you can have a tribunal appointed expert and save costs and help the tribunal. But I think in the ones that I have been involved with, the tribunal have been very firm and been very they understood the role, you don't want anyone to be challenging the award because they've devolved any decision making to the expert, which isn't right. And so the tribunal needs to be really aware of their obligations and how they write their award in times where they're taking just the countenance of one expert.
Well, that's an interesting topic. I'd love to continue on. I'm sure everyone at the table probably has their views. Depending on where you sit at the table, it can either be terrifying or enlightening. But I'll actually ask Melody to kind of comment as well, kind of on our general topic, in the context of renewables and the potential for disputes. Again, from your perspective, we've heard the perspective of our expert. What about from the attorneys, the lawyers' perspective?
It's absolutely essential since this is our profession. But I think more seriously, I think Jonathan has already covered effectively the reason why one would want to go with arbitration. But I think there are a couple of points that I'll like to highlight on. Definitely, firstly, because a lot of these projects, particularly in this part of the world, there are areas which are less developed and not in relation just to the jurisdiction, but also the local courts. So going to local courts, there are always a lot of concerns in relation to that, and arbitration will provide you with that neutrality and also the ability to stay away from the local courts. Obviously, apart from whether the relevant local courts are reliable, there's also a concern about protectionism and whether, when you're dealing with interests of local governments, when you're dealing with local big investors, whether there will be some form of protectionism involved in that. And also the fact that if you were to go to the court system in relation to some of these projects, you may be navigating throughout, different legal systems as well. A lot of these little countries, they do have projects across the countries, particularly in renewable situation. And so if there were any disputes arising in a particular point, you may not just be looking at one country, but you'll be looking at the others as well. So with arbitration being international arbitration particularly, you'll be able to choose a neutral forum, you'll be able to choose your own arbitrators, and bring in the technical expert as well. That to us is definitely one of the reasons why we would favor arbitration. And also the other point that I will highlight is the confidentiality. We've all mentioned the fact that with all these renewable projects, there are a lot of new technology involved, very novel, highly technical, and all of these issues may not be that appropriate to be discussed in the public, and with the confidentiality involved in arbitration, that will help in protecting the all the IPs involved and all the technical knowledge involved as well. So I think those are the two main things that I would highlight.
No, those are a good addition from what Jonathan was saying. I think the neutrality point is certainly one that when you have a client in a foreign jurisdiction that maybe they feel less comfortable with the local courts, the discussion comes up, particularly in contract discussions. Unfortunately, sometimes it's very late in the discussions because the idea of what the applicable law is or dispute resolution mechanisms aren't usually the first thing our clients think about. But how do you deal with those types of issues when you're looking at a potential deal or a project? Is that something you do early, or is that something that unfortunately comes late?
It's part of our education program to our corporate and projects colleagues to tell them that don't call us in on the 24th hour. But yes, I think definitely this is something that we've been reinforcing and saying that it is important, because from our perspective, no matter how great your contract is being drafted, if you cannot enforce it, those are just a bunch of papers. So then that's the reason why, and also particularly in relation to these projects, and we've talked about investor state protection and whether you need to factor that in. This is indeed something that we've been trying and we've been talking to clients, hopefully right from the beginning, but every now and then you do get the last minute call just to ask what we should be doing.
I mean, you've emphasized the element of the sort of the local issue, the requirements to work with local investors and operators and have that kind of interaction with, the government actually, having a pretty close involvement as well. Do you find in those types of discussions about, how to structure the dispute resolution and the applicable law that they pretty much insist that, if you're going to invest here, our rules, our courts, and does that become a deal breaker? Is that something that, or do you just deal with it, or how do you deal with that?
I think there are some assistance, but I think there is generally an acceptance that arbitration is the right method. So I was exaggerating a bit earlier, but I think every now and then these days, rather than asking us, oh, should we be going to court or arbitration, the question tends to be where to seat the arbitration, and what sort of rules should we be adopting, and things like that. So I think it has, over the course of my career, that has definitely moved on, and I think arbitration, even in respect of working with local governments, that has been more accepted. But I think the debate then becomes where, yes, whether they'll insist on local rules or whether they will insist on local institution. But considering to the extent that there's a significant foreign investment in it, I think there is a matter of bargaining power, and I think that there's a trend kind of moving to a neutral forum.
Now, since we're here sitting, in Beijing, and we know from our discussion of the economics that Chinese investment in the region is, off the scale. There's a huge interest and commitment to investment in renewables. When, your Chinese investor clients are, say, going to, other countries in the region and supporting their, net zero goals and helping them develop the solar and wind, how do you, is there an ability to bring the arbitration back to like Beijing? Our great arbitration centers here like Beijing or Shanghai, or is there, a tendency to want to go to Singapore and use friends of Jonathan, and, where do you think the trends are going on that direction?
I've got a favorite slides which shows that over the years, again, if you're talking about 10 years ago, and there's a study on that, which I've been talking year after year, the most favorable arbitration seats would be London, Geneva, Paris, and, all of the Western country. But nowadays, the top ones are London, Singapore, Hong Kong, and Paris, with Beijing and Shanghai following very closely. So there's definitely a tendency moving to this part of the world, and also obviously with the establishment of all the great institutions within China, and also the court system supporting arbitration within China, there's a lot more faith and a lot more confidence in holding arbitration within China. So I think that trend will definitely continue. And also, I mean, obviously, as I've said, it's also a matter of bargaining power as well. And it's a negotiation point. And we've definitely seen more and more clients suggesting that we would want to come to China for arbitration. And I'm sure Huawei can supplement on that as well.
Well, you've kind of stolen my thunder, because I wanted to kind of finish off a little bit on that point, because I know Huawei has had some involvement in the energy field and promoting arbitration. So Huawei, why don't you take away? I know you have a good story to tell.
Yeah, I listened with interest of all the comments made by Jonathan and Melody. I think they are very comprehensive. And one thing I want to add is that although the client may have some queries as which arbitration institution to use and what arbitration rules to use, but if there's a dispute, they will find that actually nowadays most of the arbitration rules have become very similar to each other. So there's not much difference between the rules. The thing is that what tribunal you can get in the arbitration conducted in China or outside of China. And in recent years, there have been some queries about whether it's a good thing to come to Beijing or Hong Kong for arbitration. And the selection of Beijing to host this conference, I think it's a convincing factor to say that we have the good arbitration facility to host any arbitration institutions, arbitration proceedings. And the most attractive thing for arbitration from my side that is really the ability to form a truly international team to handle every aspects of the disputes. There would be the lawyers who are familiar with the clients, and the lawyers familiar with host states policies, and also maybe have more insights to the composition of the arbitration tribunal. And of course, we often need experts to be part of the team. So this is something that you cannot get from the litigation. And so arbitration is flexible, and arbitration institutions can react very quickly. So in preparing for this conference, I note that there's already the first Chinese arbitration center specialized in the new energy industry, established in Changzhou, because they found that there are many, there's a huge increase of the investment in the region, and there's a rising number of cases. So according to their statistics, the most common disputes are construction and engineering disputes, and sales and purchase supply contracts. And for this, to echo Jonathan's points, that in their rules, there are specifically provisions handling the experts' witness, like the parties are free to appoint their experts, and tribunal are free to appoint their expert to handle the disputes. So this reflects the feature of the energy and renewable energy disputes. That's a development. So that's what I want to add.
Well, that is a good innovation, and I think the industry will welcome that as an option. From what Melody suggested, there are many options, and our clients have the ability to consider them, and that's why you need good legal advice and good expertise to provide that advice. I think we've basically come to the end of our time. I just wanted to see if our panelists have any final points that they'd like to raise, but otherwise we can give you back a couple of minutes of your time. Also, if there's any questions from the audience, I know we haven't been doing a lot of questions, but if there was any issues that were raised that anybody would like to address, I think we'd be happy to spend a couple minutes answering questions as well. But otherwise, we can stop there. Dr. Rivas, if you ask me the question, I'll repeat it on the microphone.
The question is more related to how governments in Asia may, how do you think that they may, in general, behave with respect to renewable energy projects? Hugo actually referred to. Thank you for the recording. The question is more in terms of the general cultural set of regulations in Asia and beyond China, not only China. Hugo referred to experiences perhaps in other parts of the world where a change of government might bring an immediate change of policy, etc., under the guise of policy regulation. Some of them might be needed, some of them might not be needed, and this is not really a divided world between developing and developed countries. We saw mighty Spain changing its policies in a dire way, but the notion is more perhaps in Asia, things are planned in a slower way, but for a longer time, and therefore my question is whether this is a perception, or is it true, or do you see that a type of change in policies as you would see them with respect to other parts of the world, especially in renewables, because the investment has to be substantial. We have to go through trillions of dollars to do the change from fossil to renewables, and that takes time. So I wonder, what do you think, or what would you estimate if you had a magic box that could tell us what could happen concerning the main provisions of fair and equitable treatment, legitimate expectations, etc. So, I mean, that's a question for all you, 6.
Melody, what do you think?
I think you're absolutely right. I don't think there's just a distinction between developing or less developed countries. We've seen, developed countries, even in this part of the world, where they've decided to change a policy from a national level and also from a local level. I think it is a little bit unpredictable, unfortunately, even with the magic ball, glass ball. But I think in going forward, because of the strong international movement and also the local movement into running into renewables, I think countries have to, or jurisdictions and governments have to recognize that there's, as you said, significant investment. And if they were to attract such significant investment, they have to ensure that these investments are being protected accordingly. So I think, they will need to think twice or 3 times or 4 times before they actually change any policy and just wipe out whatever the earlier government did in relation to that. And so I think with the crystal ball, I think as people starts to learn and, with all the current exit case ongoing, and they will start to realize that this is something in order to build their country or the jurisdiction to make it more investor friendly, that this is what one has to do.
Any other comments from the panel? I think that's a great response. I mean, just this was a point that you brought up earlier, Hugo, and maybe give you the last word on this. But, from an international law point of view, just because there's a change of government doesn't mean responsibility for government measures stops. And that's, can be a key point for an investor to know that, promises are promises, so to speak. But Hugo, maybe I'll give you the last word on this point.
Yeah, it's true, as you mentioned, the state responsibility continues even if the person in charge of the at some point, the government changes. But just in the case of the ISDS cases, I would consider that the relationship between the investor and the state is a symbiotic relationship. So involving interaction between 2 different elements or persons that are living close in association, and that association will continue. So if we understand this symbiotic relationship, I think Hugo mentioned yesterday that mediation could solve problems to a certain extent, because at the very end in an ISDS case, either both parties are losing something. So.
Well, thanks very much. I think that's a great place to stop, and we're actually at the end of our time. It was a real pleasure to have such a diverse panel with different experiences and interests to address what is, I think, an issue that we're going to be talking about for a long time. But clearly, I think our conclusion as to what the dispute resolution mechanism of choice would be, I think arbitration does very well. So, and lots of good reasons to use international arbitration. So thank you, panelists. That was excellent and very enlightening. And on behalf of everyone here, I want to say thank you and indicate our thanks. And to our audience, we'll be back in a couple of hours with our next sessions, but now we'll take a break, our midday break. So we'll see you again soon.